Welcome to the Millennial Lawyer Podcast.
Welcome back to the Millennial Lawyer Podcast with Mark Shirian. Mark is a New York litigation attorney and founder of Mark David Shirian PC, known for securing seven-figure results in personal injury, employment, and complex civil cases. I'm Kevin Rosenquist, and today we're talking about what happens when the city itself is to blame for your injury and how to navigate the maze of suing public agencies like NYC. Hello, Mark. Welcome back.
I'm happy to be back.
Absolutely. Yeah, it's been a minute since we chatted, but I'm excited to get back into it and hear what's going on out there in New York. So start here. What makes lawsuits against New York City different from standard personal injury cases?
Well, first things first, when you're dealing with a case against the city or any sort of municipality, the most important thing is to file a notice of claim with the comptroller's office or the specific agency that's involved within the city. That is the most important thing because you are jeopardizing being foreclosed from ever bringing a claim if you don't file a notice of claim within 90 days. So again, you don't want to wait more than 90 days to hire an attorney. You also want to give your attorney enough time to evaluate the claim. So first things first, hire an attorney immediately so that attorney could file a notice of claim for you when you're dealing with the city. That's the most important thing. And that, when you're dealing with a private entity, you don't have to worry about filing a prerequisite before you actually are able to file a lawsuit. So that's the big difference between a regular defendant and a municipal defendant.
What exactly is a notice of claim?
That's a good question. So per the law, you have to put the municipality on notice of the claim. So what would go into a notice of claim? Obviously, your name, the date of the incident, the location, the precise location of the incident, and just the general allegations of what you're suing for. And you also need to put in your injuries and the specific money damages that you're requesting with respect to your injury. So just the who, what, when, where of your claim. So, the whole meaning behind it is you're giving the city actual notice of the claim so they can go ahead and do their own investigation of that claim. So that's what's in there. It's very general. You're not putting in case law or anything like that. It's really just facts. Where did it happen? When did it happen? What happened? And who did it happen to? So that's really what goes in there.
Yeah, I lived in Chicago for a long time, so I have big city experience. And I remember there's always issues like, okay, who's responsible for certain things? The sidewalk in front of your house or business or, tree wells, things like that. Who is responsible for maintaining the sidewalks, the subway stairs, the tree wells, all of that stuff in New York City? Is it the city or the building owner or a combination of both?
That's a great question. It depends. The New York law actually changed, I think, almost 20 years ago, before I started practicing law, where I believe previously a defect with respect to the sidewalk was, in fact, the responsibility of the city. That law changed. Now it is the responsibility of the leaseholder or the property owner that owns the property directly abutting that sidewalk. They're responsible for shoveling snow, or if they're on notice of any sort of defect, maintaining that area of the sidewalk. When you're talking about a defect within the road, so we're talking about potholes or other issues with respect to the actual road, whether it's within the crosswalk or whatever within the actual street, that usually is the responsibility of the Department of Transportation. So it's not necessarily a private owner. It all depends, but there are caveats with respect to the sidewalk and issues with respect to the roads. So it all depends, but it can be a combination of the both, like you said.
So if it's structural with the sidewalk, I mean, I understand clearing snow and ice and things like that, but if it's a structural issue with the sidewalk, is that becomes the city's issue then, I would imagine, right?
Absolutely.
Yeah.
Yes. And we do have cases like that where pedestrian was struck and unfortunately killed by a vehicle in a crosswalk, but there's a history of fatalities and accidents at that particular intersection. And it was our position that that particular intersection was dangerous and was, uh, the city knew about it. And there weren't enough traffic safety devices in that within that particular intersection. So that does become an issue of planning and maintaining that particular intersection, and that's the allegation that we made against the city in that case. So yes, when it comes to planning or a structural defect, that's completely different. So yeah, that's a good question.
What type of public property cases do you see most often?
Potholes are a big thing in New York. I'm
Mm.
sure that was also a big thing in Chicago.
Oh yeah.
So I see that a lot. Um, Also with sidewalk flags, in New York, we walk a lot. We're on the sidewalk a lot. Uneven sidewalk flags are definitely something I see a lot. Um, we also see, you know, snow, you know, black ice is a big thing here.
Yeah.
So ice that's hidden or ice that's not properly maintained and not taken care of after a snowfall. Those are like a lot of the ones that I see.
Yeah, I know a lot of people who hit the ground from because of black ice walking around in Chicago. Because yeah, I mean, for people who haven't lived in those in areas like that, it you cannot see it. You really can't tell it's there until you're slipping and sliding. It's kind of crazy.
I'm sure. I'm sure.
Obviously, it's a municipality. They don't want to pay if they don't have to. What are some of the most common excuses that the city will use to deny liability in these cases?
Okay, so when you're dealing with the city, you have to show prior written notice of the defect. You either need to show prior written notice or you need to show that somehow the city created this dangerous condition. So it's not that easy when you're dealing with the city. Now the question is how are you able to prove prior written notice? What we usually do is we when we get a case against the city, we like to file a what's called a FOIL request, the Freedom of Information Law request of that particular area and certain time frames, usually a year or two before the incident. So that way we'll be able to demonstrate if the city did in fact obtain complaints about this particular defect at that particular area. And we've gotten very lucky with being able to prove that the city either had prior written notice of the defect or, in fact, that the city or an agent of the city created that defective condition. So that's what you have to be able to prove when you're dealing with a case against the city and you're trying to sue them for negligence or defective roadway or sidewalk or anything like that.
Do you get a lot of these cases against the city a lot,
Yeah,
often?
yeah, we do.
Yeah.
Yeah.
Is it are they different in a like as far as how you approach them? I know that we talked about the notice of claim and all that, but as far as how you handle it, are they different?
I think with the procedural hurdles that we need to deal with when you're dealing with a municipality, um, we are more aware of the time constraints because you have to
Yeah.
not only do you have to file a notice of claim within 90 days, after you file that notice of claim, before you could even file a lawsuit, you have to sit for what we call a 50H, which I believe we mentioned in other episodes. 50H is the municipality's opportunity to ask you questions about your claim. And you have to sit for that before you could ever even bring the lawsuit. So
Oh, wow.
that needs to be scheduled by the city, or it could be deemed waived if they don't schedule it on time. But you have to sit for that before you could file the lawsuit. And then typically when you're dealing with the city, you have to file the lawsuit within a year and 90 days. You don't have 3 years, which is the statute of limitations of a general negligence claim in New York. So when it comes to the time constraints and the procedural hurdles that you have to deal with, yes, we're dealing with that differently as opposed to another case where we know we have 3 years to file the lawsuit. And typically when we're dealing with a non-municipal defendant, we want our clients to treat as much as they possibly can before we actually file the lawsuit, so we have a clean record. You don't necessarily have that luxury when you're dealing with a municipality. Those are usually the differences. But as far as litigation and how hard we fight, that's the same whether it's a municipality or not.
Okay. Obviously, a lot more cameras out in the world these days than there used to be. Does surveillance footage or even 311 reports play a large role in proving these types of claims?
Totally. If there is going to be a complaint against the city for a particular defect, it should be kept, and hopefully once you foil those records, it's there. That's the other thing. That's a good question. When you're dealing with the city and this information needs to be stored and kept, and you are entitled to this by law, the public is entitled to this information by law, it does make it easier to gather that information if it actually does exist. So in that sense, that could be a plus when you're dealing with the city.
So sort of to recap, we talked about several different aspects. So if somebody falls and injured or somehow injured on city property, there's a timeline here. What's your best advice for the first steps someone should do immediately after they've been hurt?
Don't wait around to hire an attorney. Hire an attorney
Okay.
immediately. Also, I didn't mention this, but with the notice of claim, they do request photographs. So you do want to take a photograph of that defect. Just the other day, I got a case and there was a defect on the roadway. We were able, and the client did provide me with photographs of the defect, but based on the address, I was able to go on Google Maps and find out that this defect was there over a year ago. So taking photographs is important. Hire an attorney. Make sure that attorney's filing a notice of claim within the 90 days. Because if you don't do that, you can very well foreclose your opportunity to bring a claim. I will say that does come with a caveat. You are able to file what we call an application to file a late notice of claim. That needs to be done within a year and 90 days. But I'll tell you right now, there's no guarantee that a court would actually grant that application. You have to show a multitude of things, one of which is that the city is not prejudiced by this late application. I don't know. I've seen it go one way. I've seen it go the other way. So important to hire an attorney immediately to make sure that a notice of claim is being filed and gather as much evidence as you possibly can to provide your attorney so they could provide that in the notice of claim. So that is the most important first step, in my opinion.
Yeah. Well, good stuff as always. If you've been injured on public property in New York, don't assume the city is off the hook. Visit ShirianPC.com to learn how Mark can help you protect your rights. Also, be sure to leave us a review. Subscribe to the Millennial Lawyer Podcast so you don't miss any episodes going forward. Mark, always great chatting with you. Thanks so much for your time.
Pleasure. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.